All right, well, welcome everyone to our second Knowledge Technologies for Democracy webinar. My name is Jennifer Edmond. I am Associate Professor of Digital Humanities at Trinity College in Dublin, and I'm also the coordinator of the KT4D project. I wanted to give some opening remarks before we move to my KT4D colleagues, Kate and Alberto. And you'll have probably noticed that I chose to entitle my remarks, "When Doing the Right Thing Seems Impossible, Making Ethical Practice, Best Practice Work in Complex Research Projects." And the reason I chose this title is really reflecting the kinds of challenges and frustrations that we've seen as a project trying to use the ethical best practice norms and guidelines that we have as individual researchers in this quite different project context. So I'll talk a little bit at the beginning just to put things into context of where the idea for this webinar came from and the challenges that we face. So let me just get my slides up so you can see those. So when we think, again, when I think, and again, this is very much a sort of a personal perspective, but I think a lot of you will relate to it as well, about research ethics, I think about the way in which that is managed and that is organized at my own institution. As an individual researcher working within an institution, this is both a very comfortable framework, but also one that has its limitations. And this is where that looking towards your institution for your ethical oversight and your ethical guidance can actually become quite challenging when you have a project that actually transcends and crosses across many different kinds of institutions. So I'm sharing here with you, this is just the table of contents of our guide to good research practice in my institution. And I think it is a good guide, and it actually is a very strong one for us in the institution. But you'll see if you look at it, in the ethics section, it's very, very clear on biomedical research. Once you get to sociocultural research, it is less easy to define this is the correct way of coordinating and organizing your ethical oversight and your ethical practices, and this is not. So this is the first challenge we see, is less of an emphasis or less clarity on social and cultural research. And you also see that, of course, in this policy, it mixes together a set of legal and ethical obligations, but also ones that go into publication, student supervision. So again, it fits an institutional context and institutional processes much more than it does one that cuts across those boundaries. And we found that this kind of approach is actually quite difficult to adapt to a multi-partner, multi-country, multi-stakeholder, complex piece of sociocultural research. So the challenges that we hit in trying to adapt what we knew from our organizations to this quite different context was, first of all, the gaps that were there in knowledge and practice. And also, when we started to look for good examples, we found that there were many. And the wide range of models for ethical oversight and ethical guidance were largely undocumented and unstandardized. And so we had to actually call on our networks to find out what some of the best ways were to undertake this. We found that we were hitting different legal and ethical codes, not just across institutions, but also in different countries. And all of this is compounded by time pressure. You need to deliver, and you need to deliver according to milestones and timelines. So we also found that there were implicit assumptions about institutional capacities. For example, whether all of our partners would have access to an ethics committee internally to oversee what they were working. We found also that we faced an expanding understanding of human subject research. And I think a lot of this is driven by the new awareness we all have under GDPR about the data that is given to us by our participants and our responsibilities, legal and ethical, for managing that. And this is all coming together to bring us, not so much into the fear of missing out, but the fear of making a mistake. I think there is no researcher who wouldn't want to adhere to ethical best practice. But when that practice seems so hard to grasp, it can be quite, I don't want to say paralyzing, because of course we move forward, but it can be quite a hindrance to moving forward in a way that you feel confident with. So what I'm going to talk about for the next couple of minutes is just some of the things that we faced and how we solved them. And I'd really love to come back to some of these questions in the discussion about how projects like KT4D, and I'm sure many of yours, can actually appropriately address the kinds of challenges we face in terms of best practice in research ethics. So one of the big questions was about ethical oversight. And how would we put together a project level disinterested oversight? Should it be a project work package? Should there be an advisory board? Should there be a single advisor? And one of the biggest problems we found ourselves discussing was, if you want ethical oversight to be disinterested, there shouldn't necessarily be any kind of incentives for that ethical advice to see themselves as associated with the project or allied with the project. And this means that in some ways they should not be paid by us for their services. But at the same time, we were asking quite a bit from these advisors, so sort of this input. And so once you start asking for reports to be written and for deliverables to be read, you really come across a difficulty in terms of how you ensure that that ethical oversight not only draws from best practice, but remains disinterested towards the project. And this also challenged us in aligning the project level with the local. And for example, one of the pieces of advice that we had was that even with a project level ethical oversight, there should still be organizational level bodies to oversee the research that was going on. However, many of our civil society organizations in our particular consortium and the SMEs wouldn't necessarily have that body internally and wouldn't necessarily know where to go to find ethical oversight. So the recommendation that we would make here, and the practice that we have taken on, is to ask these partners and ensure that these partners actually document why they have the policies they do. They will all have some kind of guiding light to show them and to make decisions about ethical behavior. But to make sure that that is actually clearly documented is one of the things we felt was really important. And also, we were advised that you can always seek advice through EUREC, which is the European Network for Research Ethics Committees. And so this is another, and they have training resources and other kinds of resources on their website, which can be quite useful for this. And of course, the other thing is just to make sure that you always build in time to make sure you can obtain those reviews when you need them, because even in particular when they're going to be complex in a project like this, you want to make sure you don't actually leave yourself without the ability to get the oversight you need when you need it. So the second set of problems that we had was simply aligning between partners. So you have partners where there are different legal systems for parallel work, for example, age of majority. In some cases, the age of the participants we were able to recruit, we were looking for adult participants, would be different. And is there a difference between a cohort that is recruited from an age of over 16 and a cohort recruited from an age of over 18? And what is the requirement for us in terms of viewing that data and those participants differently? We also had a case, and again, you may have experienced the same in your project, where we had a partner running a workshop in another jurisdiction. So how do you make sure that both the requirements for the research oversight and research ethics of that research partner and the rights and the ethical expectations of those participants would be aligned? So again, the response that we found works, and I've used this in other projects as well, would be to have a voluntary alignment among partners to the highest level of scrutiny or most expansive definition of rights. That way you make sure that you're protecting and embodying the values of the people that you're working with. And of course, there's always the question of human subjects. And you get to the point where you think, well, if I have a conversation with someone in a hallway, do I have to document that? Because is that human subject research? An academic conference. So we have this increasing awareness, in particular as we go more towards a paradigm of citizen science and co-creation with user groups, which is, again, very, very important in our particular project, of how we need to recognize the rights and the inputs of those individuals. But there is often no very, very clear definition of what a research activity is and what might be a dissemination activity. So always balancing the legal duty to inform participants with the sometimes chilling effect that too much information can have on participants that we are not paying. So again, sometimes when you're sending too much information out, it can make people feel like that's too much of an ask on them. So you really want to make sure that the participants feel that they are understood and supported, but at the same time, fully aware of the kind of consent that we're asking them to give us and the kind of data protection mechanisms that we have in place. And of course, there are particular challenges in certain projects like ours with algorithmic processes, algorithmic processing, sensitive data, and vulnerable populations. So we were advised that there is a difference between systematic data collection for research and collection that is generalized and not for publication. And this came from one of the ethics committee that we were looking for. But of course, this doesn't release you from your legal requirement to protect your participants' rights under GDPR at any point. And of course, you all would have received forms for consent for even contacting you about this webinar. So if your data or your subject populations are complex, you will want and you will need expert support. So, and this is where I hand over to my colleagues from ICT Legal, because one of the most supportive and most important things we've had in the KT4D project that has helped us move towards a more informed and confident approach to ethics has been their expert input to our activities. So without further ado, I'd like to hand over to Kate and Alberto from ICT Legal Consulting, and they can tell you more about how we handle data protection and how you might be able to do the same. So I'll hand over to you.
Thank you very much, Jennifer. Now I will share my screen as well. I am Kate Francis. I'm the head of research, data ethics, and digital sustainability at ICT Legal Consulting, and I'm here with my colleague, partner at ICTLC, Alberto Bettiol. And today we will talk about how we can protect privacy, uphold data protection, while also fostering innovation. So how can we really engage in ethical data processing? So we're going to cover quite a few topics concerning processing for scientific research purposes. We'll look at special category data, further processing of data, consent, information obligations, data protection by design and by default, which is of extreme relevance in EU projects, and more generally, of course, with any technologies or data processing. Data minimization and storage, data security, data subject rights, and pseudonymization. So Jennifer provided a great introduction that really made it clear how difficult and complex it can be to manage ethics, data protection, and also cybersecurity compliance within EU projects. And a lot of this stems exactly from the fact that not all partners may have access to the resources that they need. So they may not have access to an ethics committee, or they may not have a legal department or a data protection officer to help them deal with data protection matters. And this sometimes leads to situations in EU projects where legal partners can become overburdened by the amount of work that falls into their laps, precisely because they need to support the partners in managing their data compliance issues. And also in the budgeting phase, often consortia do not want to give a lot of weight to the legal department because, of course, other partners need to develop many technologies, carry out extensive research, and we need to start looking at legal issues as also a very prominent aspect to be considered in the budget. Secondly, good data protection and ethics management within projects requires very good communication. So if within a project, the internal communication doesn't work, if there's not a good flow of information and interaction between the different partners, the technical partners that are actually developing systems are not going to be able to implement the advice of the legal partner. So we always need to facilitate this communication. And this is something we have really managed to do successfully in the KT4D project, which is wonderful. It's a great experience for us to be able to work with our technical partners in the project and help them decide how they can arrange their data processing activities in order to protect fundamental rights. We need to recognize that there are risks for people when we process their personal data in the context of research, and there are also risks that organizations face. So on this slide, you can see a sanction that was issued by the Belgian Data Protection Authority, both to an NGO and to a researcher. This NGO published raw data of an analysis they had carried out. This was politically profiling a large number of tweets and other information which was included in this data set concerned ethnic origin, sexual orientation, so data which needs special protections. Because the organization failed to in any way implement adequate security measures, such as pseudonymizing or anonymizing the data that they published. This exposed the individuals who had made these tweets to potential risks. They could have been discredited, for example, or they could be discriminated against. And for this reason, the Belgian Data Protection Authority fined both the researcher and the NGO. But importantly, why did the organization receive this sanction? Because they put people's rights at risk. So really, we need to, as I was saying earlier, ensure that the legal partner is involved in key discussions of all partners of the project. And this will really allow us to embed ethics, cybersecurity, and data protection into the actual design of the project itself. So by working together as a team and understanding that the data protection and the legal partner is not there to obstruct research in any way, it's just there to help the project carry out activities in a way that prevents individuals from being harmed to the extent possible. So we really need to understand that data protection is about protecting rights. Recital 4 of the GDPR informs us that data protection was really designed to serve mankind. And here we have an interaction with many different rights. So by protecting data, we can better protect other fundamental rights, like the right to have freedom of thought, conscience and religion, freedom of expression, cultural, religious, and linguistic diversity. So data protection is a facilitator of all fundamental rights. But ethics is quite a nebulous and changing concept. So the European Data Protection Supervisor has been paying a great deal of attention to ethics even before the GDPR entered into force. You may be aware that data processing activities can be perfectly legal, but they could still harm people. So we also need to take ethics into consideration. Just complying with the law is not enough. But what is digital ethics really? This is a field which is changing very fast, just as new technologies are changing. And the scene has really changed drastically over recent years. So really, research ethics started with the Nuremberg Code, following the experimentations that were done on humans in Nazi concentration camps. After that, different instruments were implemented, for example, the World Medical Association's Declaration of Helsinki, which also included human and material data. The Council of Europe in 1997 adopted the Convention on Human Rights and Biomedicine, and here they stressed the fact that the human being has privacy, and this has precedence over the societal interest or scientific research. And so from these sources, we can identify two basic components for ethical standards. And one is informed consent. So this means we truly need to pay attention to explaining what the purpose of the research is, what the risks are due to this research, what kind of risks might individuals be subject to, and also what kinds of harms may they experience. Secondly, we have independent ethics oversight, and this can be in the form of research committees, codes of practice, also national research committees. There is a great deal of information available online, but also, as was clear from Jennifer's presentation and from the intro to our presentation, not all partners in EU projects have access to this kind of information. So, data protection concerns in research. Data protection is here to protect other rights and even sometimes activities which may seem harmless to us at first glance could have very negative impacts on individuals, precisely because we are not always able to identify these risks. It's important to interact with different stakeholders, different people who have different kinds of knowledge. For example, ethicists, sociologists, a legal partner, a technician, to fully identify potential risks. And the EU legal data protection framework is here to protect individuals from unintended use of their data, which could also be misused to their detriment. But in order to ensure that data is not misused, we need to ensure that we implement specific technical and organizational measures when we are collecting, processing, analyzing data. So maybe, Alberto, you can tell us a little bit more about data protection concerns in research and what exactly personal data is.
Thank you, Kate, with great pleasure. And again, good morning, everyone. I am Alberto Bettiol. I am a partner at ICT Legal Consulting, and along with my colleague Kate, Wendy, and Ren, we are participating in the KT4D project as ethical and legal partners. So it may be appropriate to take a step back in order to fix some basic concepts regarding data protection, and then maybe go ahead with a deep dive on how data protection impacts on research, and most precisely on social research and scientific research, because as anticipated at the beginning of the webinar, there is some kind of discrepancies between the application of the basic compliance and ethical concepts regarding the classical scientific and biomedical research, while there are more nuances regarding the research in social sciences field. However, as anticipated, it may be very useful for the purpose of our webinar to fix two basic concepts. What do we mean when we talk about personal data protection? Well, first of all, we need to start from the definition of personal data, which is provided by the Article 4, number 1 of the General Data Protection Regulation, the GDPR, which defines personal data as any information relating to an identified or identifiable natural person. So, as we can see, the definition of personal data consists of three key elements. So personal data is basically data, so any kind of information regarding a data subject. However, not all information are personal data, because all information regarding natural persons are relevant for the data protection compliance purposes. These may seem obvious for some of you, but believe me, there are many uncertainties and many misunderstandings with the stakeholder regarding the scope of application of the GDPR. which does not apply to information regarding legal persons, such as companies, institutions, and so on. And finally, the data subject must be identified or identifiable, meaning that this data subject is on one end is or a subject which name and key identifying information are known, but also the data subject is relevant also when the complete identification details of the subject are not known. A classical example is data regarding internet browsing, or the so-called IP address. And the European Court of Justice has clarified that the IP address of a user website connecting to a website is personal data, even though it doesn't provide full information about its identity, but by connecting the IP address with other information relating its behavior online, it is possible for tech company and the website publishers to identify and then target the end user. So not only identified data subjects, but also identifiable data subjects. And on the other hand, another definition which is key for our purposes, is the definition of processing, which is provided under Article 4, Paragraph 2 of the GDPR. And the definition of processing is essentially not a definition, because it says that any kind of operation involving personal data, as we priorly defined, is a processing activity which falls under the scope of the GDPR. So the mere collection of personal data, the mere storing of personal data, also the deletion of personal data is a processing activity which shall comply with the GDPR requirements. Also, it is important to clarify, and we can go to the next slide, that not all the personal data have the same level. Not all the types of personal data have the same level of protection provided by the GDPR. Indeed, besides the common types of data, the common categories of data, the GDPR identifies the so-called special category of data, also known in the common language as a sensitive data, which are categories of data which receive an enhanced and a higher level of protection by the GDPR, because they are the categories of data that may have a stronger, which misuse may have a stronger impact on the essential freedoms and rights of the data subject. As you can see by the definition, these special categories of data include racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, but also genetic data, information regarding health, and sex life or sexual orientation. And as you can see, these are some kind of data that are very important for research purposes. On the one hand, the information regarding the health status, the genetic data are the basic data that are used in the context of biomedical research, but also the key data that are used for social sciences, for research purposes in the social sciences field are classified as special categories of data. As you can see, political opinions, philosophical or religious beliefs are special categories of data. So when we perform research activity, we do not have only to comply with the basic requirements of the GDPR, but we need also to provide the data subjects involved in the research, impacted by the research, a higher level of protection, since many of the data that they are going to use is classified as special categories of data. Okay, Let's see what the GDPR provides for when dedicating some specific provisions to processing of personal data in the field of research. Well, the problem is that while the concepts of personal data processing, data subject, and so on, processing are somehow defined by the GDPR, on the other hand, does not provide a specific definition of scientific research. We only have a broad definition, a broad reference in the recital 159 of the GDPR, which states that for when we talk about processing of personal data for scientific research purposes, we do not mean simply the research performed by academic and research institutions, but the concept of scientific research shall be intended in a broad manner, involving also research and development activities performed by private companies, so also for business purposes. So when we approach the concept of research regarding personal data, we shall maintain the scope of application of the requirements set forth by the GDPR as broad as possible. Another provision that the GDPR dedicates to the topic of research is the recital 156, which contains some key and very relevant elements to this regard. The first one is the competence, is the repartition of the competencies between EU institution, European Union institution, and national institutions. As some of you may know, the GDPR is a regulation which is applied, which is directly applicable to all the member states of the European Union. So it provides a consistent and uniform legislation towards all the member countries of the European Union regarding personal data protection. Nevertheless, within some provisions, the GDPR provides for the possibility, for the chance by each member state to provide and to issue specific regulation regarding specific sectors in order to integrate and essentially increase the level of protection which is defined by the GDPR. So while the member states of the European Union cannot provide for a level of data protection which is lower from the lower of the threshold which has been set by the GDPR, there is the possibility for the member state to set a higher threshold of protection of personal data. And this, for example, happens in the field of scientific research, where each country can issue specific regulation regarding personal data protection in the scientific research field. Besides the repartition of competencies, when talking about when coming to processing of personal data for scientific research purposes, the GDPR provides also two basic concepts, two basic principles that each data controller, each entity which determines the purpose of the data processing for the scientific research shall adhere to. And these are the principle of data minimization and the modern principle, I would say, the instrument of pseudonymization. What is the principle of data minimization? The principle of data minimization says essentially that a data controller, when processing personal data, should implement all the necessary measures to collect and process the lowest amount possible of personal data in order to reach a specific scope, while the pseudonymization techniques are specific techniques defined within the GDPR, which allow to reach the purpose of data minimization. As I anticipated, so the GDPR provides a special regime for data processing carried out in the context of scientific research. Especially the European Data Protection Supervisors has issued a preliminary opinion on data protection and scientific research, which clarifies that such special regime is applicable when three criteria are met. Obviously, the GDPR applies only when personal data are processed. On the other hand, there has to be specific sectoral rules or methodology or ethics principles that are applicable to this scientific research. And third, research shall be conducted not only to reach private interests. It may be conducted also to reach private interests, but to be qualified as a scientific research for the purposes of the GDPR, it shall also have some kind of impact on the society as a whole. So, with respect to the processing of special categories of data, so the sensitive data as defined before, another key distinction is the one between primary use of personal data and the one regarding secondary use of personal data. When we talk about primary use, we refer to the fact that each data controller collects and starts processing the data only for the purpose of scientific research. So they start a scientific project and they start collecting the data for this purpose. Actually, the most common case is the one in which the special categories of data are used for secondary use. So the data controller already detains the personal data and for other purposes, and then uses the personal data for the scientific research purposes. This is the typical case of healthcare organization in which they already detain the data for providing the medical services, and then they perform a secondary use of this data for scientific research purposes. To comply with the GDPR, it is key to respect the rules on the legal basis of processing, and to this regard, I will leave again the floor to Kate.
Okay. So now I would like to mention the relevance of consent. We will also talk about consent being informed a little bit later in the presentation, but the GDPR requires consent to be freely given, specific, informed, and unambiguous. And if you're processing special category data, the kinds of data that Alberto mentioned, which deserve specific protections, such consent needs to be explicit. So when we're thinking about the freedom of consent, we can look at the example of clinical trials and the critical issues that arise with consent in that context. So we can imagine that there could be an imbalance of power between the data controller carrying out the research and determining how the research is going to be carried out and the research participant. This could happen, for example, if the research participant is in poor health, or if they are socioeconomically disadvantaged, or simply if there is some kind of hierarchical situation which leads the research participant to be vulnerable or dependent on the data controller. And so this would lead to a situation where consent is not free. And in order for the research to be carried out, another legal basis would need to be relied on. So, Alberto, I would ask you to give us a little bit more information on consent in research.
Yeah. So, when using the consent of the data subject as a legal basis for the processing, which is essentially the most common case, the most frequently used legal basis for perform scientific research, a key element of the consent to be compliant with the GDPR is that such consent should be freely given. So, meaning that when the data subject provides consent to a data controller to perform data processing activities for scientific research purposes, there shall be no imbalance of power between the data subject and the data controller, so that the decision by that subject to authorize the use of their data is the consequence of a decision which is free in its determination. And the other end of the principle of freedom of consent is that there is also freedom to withdraw the consent at any time, meaning that in a manner which is as easy as the data controller collects the consent, also the data controller shall provide the data subject with an easy way to withdraw the consent, meaning that after that the data subject has withdrawn their consent, the data controller shall cease the processing activity and essentially delete the personal data, notwithstanding the fact that the processing activity performed before the consent withdrawal remain perfectly lawful and compliant with the GDPR.
Thank you, Alberto. So as I was saying, we also need consent to be informed, and this can be quite a challenge. We recognized this also in the KT4D project, where exactly as Jennifer mentioned, we were working in different countries. So this led to us drafting the initial information notices, which were going to be provided to the research participants in English, but then, of course, they needed to be translated into the local language to ensure that they were understandable for the research participants. And anytime you're translating an information notice, it's very important to ensure that the translation is accurate as well. We've observed sanctions from European data protection authorities for failure to ensure the accuracy of the translation of a privacy policy. Of course, writing a privacy policy in a clear and plain way as required under the GDPR is a big challenge. We have these complex legal notions that need to be made clear to individuals participating in the research. And importantly, the research participants need to have a good understanding of the risks that they may be subject to because of their participation in the research. And as Jennifer mentioned, this could potentially have a chilling effect, but it's very important that organizations carrying out research are transparent and allow the individuals to determine if they really want to participate based on their own evaluation of the risks. We can suggest, for example, if time allows, of course, also as Jennifer mentioned, time is always an issue in EU projects where we have very strict deadlines, but if possible, an ideal flow would be to draft the information notice, have several individuals revise it to ensure that it's clear and understandable, and then to even test the understandability of the information notice with a sample group of research participants in order to ensure that it is actually understandable for them. This is particularly complex if we think about working with certain populations that may have limited literacy or in general may be vulnerable and not in the position to completely comprehend risks posed to them due to the data processing. So the obligation to inform individuals does not always apply. As a rule, though, we should consider that it does apply. There are some exceptions. such as when the individual already has the information, or if it is truly impossible or disproportionate to provide them with this information. However, in those cases, a very careful evaluation needs to be carried out, and this should also be documented. Also, if you have collected information for one purpose, and then you would like to use this for another purpose, which was not made clear to the individual in the original information that you provided them with, it's necessary to provide them with new information so they can understand what you will be doing with their data. So now Alberto will tell us a little bit about data protection by design and by default, which is precisely what we mentioned at the beginning of the presentation as something we're very proud of having successfully implemented in the KT4D project.
Thank you again, Kate. Now we'll go ahead with a quick overview of the key principles and the key requirements that should be implemented when processing personal data for scientific research. I suggest that you can see some kind of tips that may be useful for your research purposes if you perform such kind of activity, and then maybe in the Q&A phase, in the Q&A session, we will be able to provide you with more information in this regard. So, first principle and first tip: data protection by design and by default. What does this mean? Data protection by design and by default means that when projecting a new processing activity, a new project, in our case, a research project which involves personal data, since the design of this kind of project, the ethical and legal experts should be involved in order to assure that, on the one hand, the data minimization principle is respected, meaning that, as I anticipated, the lowest amount possible of data shall be collected. And on the other hand, the process shall be assessed in order to verify its compliance with all the provisions of both the GDPR and, if relevant, national regulation. This could lead also, for example, to performance of a document provided by a document defined by the Article 35 of the GDPR, which is the Data Protection Impact Assessment, which is a document that should be archived by the entity which is performing the research project in order to demonstrate its compliance with the GDPR. Thank you. How can we reach data protection by design and by default and data minimization? As I anticipated, one technique to reach this is to pseudonymize the data, meaning that we can segregate the personal identifiable information from the content of such information. For example, in medical research, we can archive the medical record of a subject, not presenting in the document and in the files the name and surname of the patient, but simply an ID code of the patient, and to archive in another storage, in a separate storage, which is accessible from subjects which are different from the ones that are performing the research purposes, the connection between the identification code of the patient and their name and surname. Be aware that pseudonymization is different from anonymization, because when we have a pseudonymized data, we still have personal data which fall under the application of the GDPR. While when we have anonymized data, we have, let's say, deleted the connection between the ID code and the full name of the patient. And in this case, we have no more personal data, and so the GDPR does not apply. Again, as I anticipated, a key principle of the GDPR, and especially when performing research, is to respect the data minimization principle, which means that when performing a project which requires the use of personal data, the lowest amount possible of personal data should be collected and processed. And this principle, the data minimization principle, on the other hand, is not related only to the amount of data collected, but also for the period but also to the duration of the processing activity. So not only I have to collect the lowest amount of data which is necessary to perform the processing activity, but I shall process such data for the minimum period of time which is strictly necessary to achieve my scientific research purposes. So, as a key takeaway, when starting a research project, please define, on the one hand, the strict amount of data you need to collect, on the other hand, the strict amount of time you need to perform such processing activity. Once the period is finished, such data should be deleted or anonymized, as we defined previously the concept of anonymization. And for sure, most importantly, since we are experiencing, also due to the current geopolitical situation, a huge rise in cyber attacks, especially targeting scientific research organizations and healthcare organizations. So another key element is to preserve the security of the data, meaning that the data should be protected by potential data breaches, where for data breaches we mean any event that will lead to a loss of confidentiality, integrity, or availability of personal data. Just some basic tips regarding data security, but I am sure that your organization may rely on specific standards such as the ISO 27001, which is the key standard on security. So obviously to ensure security of the data, robust password and authentication management processes should be in place. Also, specific policies shall be enforced regarding the use of cloud services and storage of data in cloud infrastructure. And also don't forget about the physical security of the organization. So both paper copies, but also the servers, when they are on premises, shall be protected from unauthorized access, but also from catastrophic events such as earthquakes or fires and so on. Okay, once again, please.
Thank you, Alberto. It's as a side note, it's interesting to recall that the UK Data Protection Authority actually sanctioned a company for having damaged documents. They stored documents in a cardboard box, and this box was damaged by water. So we also really need to think about protecting information from the elements. Just as we need to think about protecting the rights of data subjects, as we have made clear throughout this webinar, data subjects have different rights, and they need to be informed about their rights under the GDPR. They need to be able to stop participating in the research if they decide that they no longer want to. But we also have to recall that these rights are not all absolute rights. They might not all apply in all cases. And very important as a practical tip, organizations need to have in place a procedure for dealing with data subject rights. So of course, if the research organization has a DPO or a legal department, they should be the one to deal with data subject rights. But if you don't have that kind of figure within the organization, it's very useful to set up a policy for how data subject rights are going to be fulfilled in the context of the research project. And Also, we need to note that there are some derogations in certain cases from these rights, which can be applied. But in those cases, when we always need to ensure that adequate safeguards are put in place. So, for example, anonymizing data or pseudonymizing data, when that may not be possible because it would interfere with the purposes of the research, there are other possible solutions that can be found. So really, what we wanted to make clear is that the data protection rules are not here to obstruct research. They're here to facilitate research. They may be difficult to navigate, but there are many useful resources from, for example, the European Data Protection Supervisor, which can be relied on. And last but not least, it's fundamental that the fair data principles are complied with. Data needs to be shared in order for its value to be truly taken advantage of. Europe is looking towards research and innovation, also with the aim of boosting the economy, and new innovations are much more likely to be realized if data is shared and made accessible. And here we need to specifically look at machine actionability and metadata. So we can never forget the fair data principles. So in conclusion, we want to say that research, data ethics, and data protection allow us to carry out research in a way that protects the fundamental rights of research participants. And following these rules, ethical best practices, which we always need to continually update, and also following the rules on data protection can both contribute positively to society and prevent harms from occurring as a result of research. And we also don't want you to be afraid of data protection experts or lawyers, because they are really there in the EU project to help you and to ensure that the research has the best outcome for everyone, for the research participants and for those carrying out the research. So thank you very much for your time and for having joined us here today. It was a pleasure to be able to provide this presentation, and we'll now move to the Q&A.
Thank you so much for that, Kate and Alberto. That was a fantastically informative and yet very well condensed and comprehensible overview of the issues and the way in which you are obviously supporting us in KT4D to do the right thing and feel confident about it. We only have a few minutes for questions, but there's a few really good questions in the Q&A. So hopefully we'll get to most of them. And even if we don't get to all of them, obviously at least we'll be able to circulate some information after the fact. I'll start with the first question from June Mercer-Chalmers about communication platforms. And I think this is a really important one. I think we've had to become very aware of the fact that some of the data storage and communication options that we've been used to using in the past may not actually be ones that protect data under GDPR. In KT4D, interestingly, we do use a Google Suite approach. However, and this is a very important caveat, it is one that is paid for and that is owned by one of our partners. So it is something where we do have the GDPR protections for our data that you wouldn't have if you were just using it off the shelf. So I think the most important thing is whatever platform you're using, make sure that you understand how they are managing your data, in particular, whether they're moving any data offshore, because this can be one of the key things with everything from transcription platforms to data storage to communication platforms. So those are ones that we look for, and of course that they have the right kinds of data security in place. With just a couple minutes left, I wanted to maybe turn to Alberto with the question from Jose Ribeiro, because I think this is a really important one about when we have data sets that were collected 20 years ago, before we had the current legal regime and before we would have had the same kinds of requirements around consent. Can we still use those data sets, and how can we merge those with the ones we're collecting now?
Yes, and I think that the question from Jose, it's somehow connected with the question by the Finnish colleague, because essentially the problem that they are facing. Okay, we have a data set for which or it is impossible to collect a consent from the data subject, or it is let's say very challenging and not practically feasible to obtain consent. And this is a field in which each member country of the European Union has provided specific rules. But in this case, and I can provide you, for example, with the Italian experience. In this case, the Italian Privacy Code, which integrates the GDPR, provides a rule based on which scientific research for subject regarding which, for the secondary use of data, for which it is not possible to collect a specific and free consent by the data subject, may be studied essentially on the basis of a public interest prior to performance of a data protection impact assessment. So the research organization shall draft a report regarding the possible negative impacts of such processing on natural person, and typically prior starting the project to consult the local data protection authority to present the risks of such processing and obtain or the authorization of the data protection authority or the recommendation of the data protection authority that shall be then embedded in the research project in order to ensure the protection of data of the participants to the research project.
Excellent, very useful. So hopefully, Jose and Simo, hopefully this gives you a little bit of a response to your questions, but unfortunately that's all we have time for today. But thank you very much to everyone who's joined us for the webinar today. I hope you found it useful and informative, and we look forward to bringing you our next webinar in a few months' time, and we look forward to having you back. In the meantime, I wish you all a very good day and a very good week. Thank you very much. Bye-bye.